down with OTC? Are you down with OTC? OTC. Are you down with OTC? Are you down with OTC? OTC. Are you down with OTC? Down with OTC. Down with OTC.
Welcome to part 4 of the SEC v. Ripple Teardown. Welcome everybody. What's going on? Well, hope you're fine out there, doing well, getting prepared for 2021, because 2021 can certainly be, even if it's that much better than 2020, will certainly be welcome for all of us. So I just wanted to just welcome everybody, and I'll do a little shout out here in a second, but I wanted to we're going to go in, we're going to find out some uncover some other things. There's been some new developments. Want to know what kind of impact that's going to have on Ripple and or XRP as a whole. And there's some other things we want to share, some other people chiming in about this this SEC case, both on the positive side and the negative side. So let's go.
And now, the XRP Minute with Chip on the chain.
Chip here with the XRP Minute. If it's your first time here, please like, subscribe, click that little notification bell, and you will be notified anytime we go live. And guess what? We're going live in a few hours. Jeff and I are going to do a stream. We're going to do our typical Wednesday night stream, 8 p.m. Eastern time, Miami time, New York time. So I'll probably tweet that out and then put a little legend in there that tells what time zone you're in. You'll be able to figure out what time we go live. So without further ado, let's jump into the chat section. And look who's first. It's none other than my co-host, co-founder of On the Chain, Jeff from the HODL Review. And we also have Channing Smithson in here. He is already an alumni of the Roundtable show. And we have Crawfish XRP, XRP Chance. Doc Callum is back. Hey, Doc, good to see you. Rod Hop from North Carolina. What's up, Rod? And then we have, of course, none other than Connie Stewart, who is always, probably one of the biggest cheerleaders of the channel, getting people already like, subscribe, hit that notification bell. Thank you for that, Connie. And I want to jump into a couple things here. First off, let's go. Oh gosh, there's so much to look at here. Let me see. It's always funny when you have this stuff set up ahead of time, and then all of a sudden you can't find it, right? It's like it's there, but then it's not there, and then oh my goodness, good lord. So let's start off with this right here because I think when we're dealing with I guess I would probably prefer to call someone like this an asshat because that's really what they are. So here we go. So here's Rand Nooner. So so-called proclaimed self-expert on all things crypto, and he's been really active in tweeting stuff out. Hey, we should all thank XRP and Ripple for the flying in BTC price and for kickstarting the alt season. People are selling their XRP and putting their money into alts and BTC. Oh, really, Rand? Is that what they're doing? Huh. Did not know that. That's interesting to know. It's well, I mean, what an assumption, right? What an assumption to go ahead and make that, to say something so ridiculous like that. But that's Rand. That's what he did. He had something out the other day too that I responded to. Some other silly thing that he was going on about, XRP and then Ripple and blah blah blah. And it's a silly thing that he does pretty often. And next thing I wanted to look at here. Something that I really found, and I think you guys, if you haven't read it yet, but I want to go through it because I think it's just phenomenal. I think it's amazing on so many levels. Let's go ahead here and let's go ahead and share this too. So we've seen a lot of people chime in, a lot of people chiming in to say whether or not they like XRP or Ripple or what they think. Obviously we saw that Coinbase responded and they have suspended market trades, but and also coming up on I think it's the 20th or the 21st, they're going to allow you to still custody your crypto. So either whether it's institutional custody side and or using their wallet, so that's not going to change. They're just you're only allowed to put limit orders in right now, and then they're going to suspend all of it. But you have to remember that they are going through an IPO. So when you're going to go ahead and you're going to go public as a company, guess who regulates that? That's the SEC. So yeah, it makes a little bit of sense that they're going to do that, in a lot of ways. But I wanted to show this because JP Thero, who you guys know as he is the CEO and founder of Uphold. And he put out a brilliant thread. And, I'm really love the way he crafted this. Let's jump through it. If you haven't read it, let's go through it together. He says, Uphold hopes that due process resolution to the SEC Ripple dispute can both set the goalposts for token offerings going forward, as well as clear the fog bank of uncertainty that now presumably settles over the Stellars and Filecoins of the world, if not ETH itself. Let's break this down. There's a lot going on in this opening statement. And I got to tell you, there's a reason why I have a lot of affinity and love for Uphold. I love what they're doing as a company. I love the direction they're going, their interface, everything they touch, all their touch points are really well orchestrated and done. This is one of the most brilliant threads that I've seen on the subject, okay? Because this one right here, there's a lot said in a lot of words. When he talks about Ripple can dispute the goalposts and the offerings going forward, clear the fog bank, right? Clear this whole idea of uncertainty over the last 7, 10, 11 years if we go back to the inception of Bitcoin, right? And he's saying presumably it settles over the Stellars and Filecoins of the world, if not ETH itself. Now here, and when we've been workshopping this in parts 1, 2, and 3, and now part 4, one of the things that we've talked about here is the fact that, yeah, the SEC can giveth to ETH and Ethereum saying that it's not a security, but they can also take it away. Now, if they're going to uphold their, funny I just use the word uphold, if they're going to uphold their statement that ETH is not a security, then we've got some big problems here. Because if you have Vitalik Buterin saying publicly, thanking an investor publicly for a purchase to keep the company alive, well, if that's going to be okay, and that's going to have standing, and that's going to be okay, then this is what's amazing about JP, because he really understands it on a deeper level. And the reason he's bringing up the Stellars and Filecoins of the world, he's basically saying what's at risk here is the entire crypto market. And well said. And he says, if not ETH itself. Now, some people might read this, and what they would read is, well, wait a minute, excuse me, JP, but it looks as though the SEC already deemed Ethereum, Ether, not a security. Whoa, 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 not so fast. And what he's saying here is if it were to get some sort of a ruling here against where they're deeming that XRP is a security, they got big problems, right? Bitcoin's going to be safe. Bitcoin's not going to be part of this whole thing just because of the way it was structured. But Ethereum has a big problem here because if this ruling, they think they're in the clear because they were given the green light. And right on, JP Thero gives this beautifully and well constructed. Now, let's go through to the next one. So what he says here is, he says the SEC is a lion in the service of protecting consumers and stopping bad actors, but the Ripple complaint presents various conundrums. What if punishing the actions of a couple of parties not only directly harms XRP holders, most of whom probably assumed tacit approval after 7 years of inaction, but also threatens to harm participants in similar projects, as well as virtually assure that the U.S. will not be home to Silicon Valley 2 by rights the U.S. is to own. This is powerful, man. This right here, JP's right spot on again. I really want to, so thrilling to see somebody who really gets it. And it's not just anybody. This is one of the CEOs and co-founders of one of the, biggest regulated exchanges in the United States. And, we all know Uphold. Uphold's been very friendly. And Uphold, if you remember, they came to the rescue by when Vitsovin had an issue with the XRP tip bot. He wasn't going to incur all the risks associated with that. He had to move it someplace, right? Because it started off as a project. And who stepped in to save the day? It was Uphold. Create an Uphold account. Oh, yeah. It's a nice marketing feature too. But they went ahead and did all the coding to be able to do the transfers so that you could get any of your XRP off the XRP tip bot and continue to get and continue to use and receive tips via the XRP tip bot, right? Nobody else stepped up, and it would have been you talk about conundrums. This would have been a hell of a conundrum for Vitsovin and the XRP tip bot, and it may have been a project that may have had to collapse, right? Because it was a personal project, not a company or a sponsored project. So what he's saying here, which I really like, is the fact that the SEC is a lion, right? It's the big boys, right? It's the one that can do a lot of destruction. There's a reason the lion is the king of the jungle, right? You don't mess with the lion. The SEC is the lion here in the regulation sort of sense. And he's saying that what they're mainly responsible for is protecting consumers, right? That's what the SEC is about. In this case, what he's seeming to assert here is beyond protecting consumers and the bad actors. He's saying that this complaint, what if punishing the actions of a few parties, namely, let's say Brad Garlinghouse and Chris Larsen, directly harms XRP holders, right? Because how are you protecting, and this is an element that I've heard that has been brought up. We've kind of glossed over this a little bit here in workshopping this, but what he's saying is that their main fiduciary, their responsibility to protecting consumers kind of oversteps, especially when you have FinCEN, who has stepped in and has already voiced in and has audited the books of Ripple for the last 5 years, and they've been doing everything because they were fined, right? They did make a misstep, but they went ahead and corrected it. You can only correct, and this goes back to David Schwartz's statement, that you can correct what you know. If somebody says you didn't follow the rules, they say, well, what are the rules? Let's go back to the Howey test in 1933 and 1934 Exchange Act. Okay, yeah, we could, but there was no clear regulation. There were no lines that you had to be aware of to be able to step over. And in following up here, he says that most of who approve probably assume tacit, a small approval after 7 years, right? Some sort of an approval. And he's really calling out the inaction here, right? So he's calling out the SEC by they're really happy to go ahead and levy this against Ripple and Garlinghouse and also Larsen, but where's the regulation? Why didn't you come out and spend a lot of time putting the regulation together? So we're looking at, hey, this is granting tacit approval. But he says his main point is that it threatens the participants in similar projects. So we all know the value, but I think the altcoin, and even Rand Newer, who's putting out these tweets, it's the alt scene the alt coin marketplace, yippee yahoo. Well, listen, bud, that's some bad news for you. If this goes badly against Ripple, it crushes and destroys the altcoin market. Not around the world, just in the U.S. And what he brings in later is the fact that no longer will the Silicon Valley 2, which is crypto central, all of these fintech startups that have had, have really put forth all of these phenomenal problems that they're solving using a digital asset or a cryptocurrency. And he's saying goodbye to Silicon Valley 2. And that is the U.S.'s to own. Boom, I like that as well. He's saying a lot of the innovation that came out of the U.S. And look, don't take this the wrong way. This isn't him blowing the horn and saying the U.S. He's not being really jurisdictional or pro-U.S. or anything like that. What he's stating here, in my opinion, what I'm interpreting here, he is going down to the brass tacks here, and he's saying that rightfully Ripple was founded in the U.S. Right? It's a U.S. company. It's worth $10 billion. And there's a lot of other companies that had to move. And he's kind of just cheering on the fact that the same way we have Silicon Valley, which is well known for the tech sector, in San Francisco, and also if you go a little further south to Mountain View, it's also the realm of the Ripples of the world to be able to claim this. That is one of the biggest things. And I really love the statement. This is one of the best tweets. I might have to frame this and stick it on the wall, because this right here is some golden positioning and words. So it says a lot with very little. Next up, and before we go there, I'd like to say big thank you to Jade. Thank you very much. Yeah, thank you very much, Jade. I always appreciate your support of the channel. It means a lot to Jeff and I really appreciate that. Thank you for that $19.99. That's amazing. Beautiful. Thank you so much. And if you have questions too, you can throw the questions in there. We will put them up as well if I can see them. And if I don't get discouraged. You might have to add it in there, but maybe Jeff will help if he sees a comment we want to elevate to the screen there. We can also do that. So going on with this, one of the things JP continues with, he says, can something be born a security and then metamorphosize into something else? How is invoking $1 billion losses for innocent third parties, as an ex-commissioner of the SEC recently put it, in the interest of protecting consumers? I love what he's doing here. He is calling SEC to the mat of what their fiduciary is. Their fiduciary is to go ahead and check consumers and make sure the consumer's protected. Who are the consumers in this case? It's us, right? It's you. You're the ones that are willingly grabbing. You're the ones that made the investment. You put your hard money at work. You went ahead and took the risk. You went ahead and did the research, and you invested. Now, who is this going to hurt the most? And this is what I love about it. He's calling it out. And when you ask questions are powerful. When you ask a question, there's a lot behind that. Could this potentially metamorphosize into something else? Could a security metamorphosize into something else? It actually can. It's something we have talked about, Jeff and I, going through this the last few days. But in our parts 1 through 3, we've been mini workshopping this together. One of the things that we talked about was, what if early days it was a security, right? And I love that he's asking the questions. He's not making a statement or an absolute. He's asking a question. What if something could metamorphosize, right? And maybe early days, back in the day, when Ripple first, started as a company, and then XRP, OpenCoin, then XRP later. What if, because of the centralized control over the asset and the decentralization over time? Now, isn't this what Hester Pierce, crypto mom, has been advocating, right, inside the SEC? Isn't that what she said? How about 3 years, given safe harbor to any fintech company that would like to put forth an idea, solve a problem with a digital asset? They would have 3 years to do so, and in 3 years, given safe harbor, develop an infrastructure and decentralize it and a coin offering. It's a brilliant proposal. And again, this is more along the lines of what the SEC should have been doing. But instead, they became litigators, right? Going after the company who's so responsible. I mean, if you look throughout the the course of all of the companies, and this is just opinion, but I don't see any other company that's been yelling and screaming for regulation, who's been out there publicly stating, hey, where are the lines? Put the lines in the sand so we know what we're supposed to operate under. Even going so far as to threaten to leave. Now, sometimes you got to be overly dramatic to prove your point. I think that's exactly what's happened. I don't believe that Ripple has any intention of leaving the United States, but they make a very good point with some drama. Hey, we can't deal with this anymore. We got to get out of town, right? And if you look at the fact that 90% of Ripple's customers are operating outside the United States, even if it's deemed a security, you know who loses big? Not Europe, not Asia, no, not even Australia, not the UK. You know who loses big? The United States. You know what happens to the marketplace here? Dies. You know what happens to innovation? Pops up everywhere else. You can't put this genie back in the bottle. So he's also referring to the ex-commissioner who was talking about protecting consumers. Now, let's go back through this. Now we're on 5 of 8 of his statement here. Let me blow this one up. There we go. Now, we work in the most exciting industry of our day. This truly is the second coming of the internet. As with all human activity, there is well-intentioned, the criminal, and the crazy. But most importantly, there are innovators, the agents of all human progress. What I find so startling and amazing is how much he takes and condenses into a few words. This is very well thought out and drafted. Yeah, we are in the most exciting. We've often compared the XRP community, the YouTubers, the thought leaders have often, on Twitter, all the researchers have always compared this to what happened when the birth of the internet, right? The birth of the internet happened. No one knew it was going to happen. No one even knew. They wanted to overregulate it. That was like, nay, don't overregulate, right? And one of the things that came out is what we had, just a booming operation, which happened in the 90s here in the U.S., but it touched all parts of the world, and it also brought the internet to all corners of the world, which is phenomenal. It continues to do so. I mean, it's amazing how many people yet don't have access to the internet. You'd be shocked if you saw the stat. I read it the other day. I don't want to quote it because I don't want to be wrong in it. But what he's saying that this is the second coming of the internet. The second coming being this brand new opportunity that is going to be not only as a new asset class, but is a phenomenal. And quite honestly, even though they're comparable to how they got started in birth, this make no bones about it. This is the greatest thing to happen to the entire world. But who's fighting it? Oh, let's see, the central banks, the people that are against that. Bitcoin, the promise was, hey, we're going to have this, and we're going to shun the banks. We're going to shun we're going to shun all of the regulation, all this kind of stuff. Now, when Ripple took a look, I mean, one of the things that Ripple did, and this is why they should really get a lot of credit. They looked at the shortcomings of Bitcoin and said, let's make it better, let's make it faster, let's make it cheaper, let's make it a product that can be utilized in so many different use cases. And this is what they did, right? And so who's the one? You got the lion coming after the big kingpin, right? Coming after that like some kind of mafioso shakedown here. And that's what's happening. And he's going into and he's bringing in that with all humans, no matter where you break it down. You go to some small tribe that doesn't know the outside world, they've got a criminal element. There's somebody in that tribe that's not, is not on the up and up, and this is what's called the human activity he's talking about. Yeah, everything's well intentioned, but guess what? There's always going to be the nut jobs, and there's always going to be the criminals. But he says these are the innovators. These are the people that are making a change in our world, that are doing something that exceeds everything else, right? So, and this is one other thing I love about that. These are the agents of human progress. What is human progress? It was recently on the XRP Minute. We talked about progress. We talked about the flushing toilet. We talked about, electricity. We're sitting around thinking this stuff existed forever. No, man, go back 100 years and find out what life was like. Go back 120 years and find out how amazing your life is now compared to that. Guess what's part of that? This is the Internet 2.0, right? It's the other next big thing we are moving forward with. So this is the agents of human progress. Perhaps the innovator in question poked the lion and got swatted. Now we have to see whether the lion gets up and finishes the job or returns its attention, more likely and deserving, next meals. It's this next action that holds the promise of providing the clarity we are all hoping for. Meanwhile, we'll tiptoe in the fog, listening to the party happening in the panda enclosure and the amusingly bitchy schadenfreude of some of our colleagues, right? Now, he pokes a little bit fun. There's a lot of tongue-in-cheek going on here when he says, we're going to just, hey, don't worry. We're just going to like wander around in this fog, tiptoeing around, not knowing where the line is. But we'll be listening to all the, the chatter from the panda enclosure and the typical bitchy stuff of our colleagues, better known as the crypto Twitter or wherever it may be, right? And he goes on to finish this thread with a, whoa, here we go. Uphold will continue to list XRP until and unless the complaint is adjudicated against Ripple, specifically citing that XRP is today a security or trading volume dissipates to a point where we can no longer support. Okay, so finally, somebody steps up and sees this for what it is. A lot of people are saying on the internet who have incorrectly saying stuff to the point of like, well, Ripple's been charged or Ripple's been has been no. This is a complaint. These are allegations. Until any of them are proven in a court of law, they're simply allegations. And what he's citing, the fact is that until there's a ruling that says XRP is a security, okay, that's the first condition. The second one is, suppose volume drops to the point of where nobody's buying, selling, whatever. I mean, as an exchange, Uphold can no longer, they have a business model. So what he's saying is now that's a point he's making, but I don't ever see that happening. But what he's saying and citing here is that if it didn't work as a business model, we wouldn't continue to support it. Not as a company, no, we wouldn't do it. Now, I don't see that happening. Yeah, we've seen the price drop, but we know there's a lot of trading going on. It's amazing. If you go to Fiat Leak, just look at Fiat Leak right now. Just look at that thing. It's like going crazy, right? All 24 hours of the day. It's just amazing, right? So I want to go through a couple of comments here, whatever. I want to see what anybody had any questions here. Let's see. So let's see what XRP Chance says here. Regulation effectively doesn't exist yet. Yeah, so XRP Chance, how can Ripple comply with a regulation that effectively doesn't exist yet? 1930 regulations doesn't cut it anymore. Ripple become known as spearheading a force to change all. Yeah, you know what? Someone wrote in here that it will no longer be called the Howey test, but the Ripple test. But what it'll be called is the Ripple opinion. They'll be known as the change agent that happened that automatically buried that. And we're going to have a new sort of way to look at how digital assets are managed and how they're looked at. And they're not securities, right? And one of the things JP Thero brings up is the fact that what if it was at one point classified or looked upon as a security, but then it metamorphosized into something else? So I've often thought that myself. Will there be a penalty levy? Absolutely, there's going to be a penalty levy. That's what you do. You levy a penalty, you get in, you get out. But the bigger problem I think that the SEC is going to have in proving their case is twofold. The first part of it is that they have other government regulators, such as the Department of Justice, referring to the XRP as a currency, digital asset, a method of exchange, and you also have FinCEN saying the same thing. Hey, this is not a security, right? So you've got that. So when anytime you have precedents, especially with government agencies, now a lot of you are probably saying, yeah, but here in Europe we've got regulators that saying it's not a security. In the UK, maybe in Japan, Australia, right? And you're saying, well, that's not going to carry as strong. I mean, when you go to a U.S. government regulator, but you also have that as support, saying, okay, fine, but the rest of the world has said it's not a security. The rest of the world is carried out. It's moved beyond us, and the meanwhile, the United States is sleeping at the wheel. And I saw a great tweet put out last night by Oz Crypto saying that, hey, goodbye, U.S., we don't care, we're moving by. I'm paraphrasing, but he's right. Goodbye, we don't need you. And what is this going to change for anybody who's outside the U.S.? Not much. What is it going to do to the U.S.? Destroy it, if it was real to security. But I don't see that coming. Look, if you want to expedite this, and some of the new things that just happened, developments happened yesterday on the docket. There was some. We'll jump into that as well. Let me see if I can pull that up here. Let's look at that. Yeah, so I saw this by Crypto Eddie put this out here, and I was actually I want to show this right here. And she has a spot on right here. Oh, come on. There we go. I was trying to get this up here. So she's saying, this new request in the docket, it was filed yesterday. The Honorable Annalisa Torres, she was the judge initially assigned to this, and has given the option to promote efficiency and move the case to go more quickly to go before a magistrate judge rather than her, whereby she would play no further role if consent was given by all parties, meaning that in order for this to work, the SEC and Ripple would both have to consent to this. And then she pulled up this document. If you'd like to see your case move more quickly, it's helpful to consent to proceed before a magistrate judge for all purposes, including any trial, right? And this is good because we want expediency. It's definitely what we want. So I pulled it up over here. This is basically the same. This is kind of a foggy sort of a screenshot of a document, but right here it basically goes on. You got to remember, this is the Southern District of New York. There's very slight differences in a civil district, court case versus a federal court case. The magistrate plays a different role depending on, in the local sort of. This is a federally filed case. So when they talk about that, and the funny thing, if you don't know about the United States, is that we've got 50 states, and aside from our U.S. Constitution, and this is similar to some other countries, but aside from our U.S. Constitution, we also have state constitution, and each state mandates its own rules and regulations as far as how they proceed with stuff. So this has to be cited from the United States District Court in the Southern District of New York, which I know very well, believe it or not. I know that, and judges, and some of the. This is more on the lower level, not the federal level. And so this is exactly what this document right here outlines. If you'd like your case to move more quickly, right here, it's helpful for you to consent to proceed to a magistrate for all purposes, including any trial. If you consent, the magistrate judge will perform the identical function of the district judge will have performed. Any trial in your case would either be a jury or a non-jury trial. Now it looks like in the complaint, what's happening is it was requested for a jury trial, but that may not. It depends on how that would happen, right? And the only difference, let's see, any trial in your case would either be a jury or non-jury, depending upon whether there is a right to a jury trial and a proper request for such a trial, which is what the SEC has requested. The only difference is the magistrate judge and not the district judge would preside over that trial. Cases that proceed for all purposes before a magistrate judge generally move more quickly than the cases before a district judge. So what we're looking at right here is expediency, and this is exactly what we want. We definitely want this to move quickly. We definitely don't, I almost think that, Ripple has like a 20 days to file a response. There's some deadlines coming up in February, and a pretrial hearing. Now, a pretrial hearing is just that. It's a hearing to hear some of the stuff, whether or not they're going to move forward. But a hearing, there's a lot of things that can be asked in a hearing. And I almost thought that before I saw that hit the docket yesterday, that Ripple would request some kind of emergency hearing to expedite a hearing only because their business is greatly impacted. And not only, they're looking out for themselves as a company, but also what's being alleged here to the XRP community, which is the SEC's job to protect, right? Us as investors holding the digital asset XRP. So let's move through here a little bit. Let's move through here and let's see. I'm trying to look for some questions here. Michael O2 says, hey, Jay Clayton said at Congress, if you try to stop it, I'll just go around it. I'm not sure what you're referring to there. It'd be good to know exactly what you're talking about. DLT says, we're in good hands. I think we are in very good hands. I would really 100% agree with that. And then Channing Smithson says, other cryptos, seeing how the SEC handles Ripple, feel as though it hampers progress, stifles future endeavors. Exactly, and that's exactly what's being said by JP Thero, the CEO of Uphold. That's exactly right. I mean, what you're doing is you're crushing innovation. This is very different than what happened with the internet when the regulators tried to step in, right? We've got exactly the opposite. Now it's different in the sense that we have financial instrument versus a technology instrument. They're different in that sense. But the bottom line was the outcome of what happened with the internet, by not stifling it and crushing it, it just was able to blossom and flourish, right? And suppose it would have been crushed early. Would it have turned into as important of a? I mean, can anybody imagine not having email today? Can you imagine not, hey, just Google it, right? I mean, can you imagine what life would be like if they had crushed it? That's where we're at now. The difference is the world is way more clever, right? Thank God for what's happening in Europe, what Japan is doing, what's happening in Australia, the UK. Thank God for that. You want to know why? Because they're not sleeping. They are moving forward. They don't give a wit's end what happens with the US. And sometimes the only thing that happens, guess what? Then you're forcing Ripple to leave, right? There goes a $10 billion company, and now you got people vying for come here. Yeah, Singapore is like, come here, and you got Bahrain or wherever else they were supposed to go, trying to then now win them to come over there because they want them, right? They're open arms saying, please come here. So let's look past here. Let's see if there's any other questions you guys have. If you do, just go ahead and pose them up there. We'll see what we have. We'll throw this out there. Now I wanted to go into something else that I think is kind of really pertinent. I'm going to jump around a little bit in the. I want to jump to another section of this in the teardown here. I'm going to jump to section 392. This is in the complaint SEC v. Ripple, and so when we get to the whole idea of tolling agreements here, you go, what is a tolling agreement? Well, a tolling agreement is this extra outside the judicial agreement, which limits between the parties, that limits this whole statute of limitations for counterclaims. So what they did was they entered into an agreement with the SEC, and they entered into the agreement here. You can see first time was April 1, 2019. And 2019 through June 2019. So you can see, we talked about the fact that this was well known for a while, right? Now I don't know when the actual sort of discovery, but the actual first time there was basically dissolving any statute of limitation was from April 1st, 2019 to June 30th, 2019, right? Then from July 7th through September 7th, then through September 19th through December. So you can see how they kept going. It kept going. So this was like ongoing until we got to June 9th of 2020 through December 9th, and ultimately for December 10th to when this complaint was filed through the 24th. So it expired on the 24th. Now have they this complaint came on December 23rd. We don't know if there was another tolling agreement between Ripple and the SEC, right? I would imagine there's going to be something. I don't see why, to a court of law, you want to have a tolling agreement. You want to say, let's put it all on the table, right? You don't want to sit there and hide behind the statute of limitation ran out. And the reason they're doing this outside, because we've talked about it before, that there was a ruling where the statute of limitation only applied to 5 years going back. But what this tolling agreement does basically suspends all that. And when we look at, and the reason I'm bringing this up is because what they're actually looking for as far as the claim and the relief that's being sought by the SEC. Here we have the commission realleges and incorporates by reference here in the allegations paragraphs 1 through 393. And we've been breaking it down. I think we ended up at page 29 out of the 71 pages of complaints. This one is, this is 67, page 67. So I'll jump through some of this pretty quick, but the defendants directly and indirectly made use of the means of instruments of transportation or communications in interstate commerce or the mails to sell securities through the use of medium of any prospectus or otherwise, and B, made of use of the means and instruments of transportation or communication in interstate commerce or the mails to offer to sell through the use of medium of prospectus or otherwise, securities as to which no registration statement had been filed. That's a lot of words that basically says that they did not classify, did not file with the SEC and announce that XRP was a security. and because it was used in a commerce way, and it was also across states, they're levying the fact that they were doing ongoing stuff, but they were not filed with the state. Then you have Ripple violated sections 5A, 5C of the Securities Act by conducting this offering. So they're citing it back to the original to the Securities Act. Ripple violated the provisions by, amongst other things, from 2013 to present, directly and indirectly making use of the means and instruments of the transportation, blah, blah, blah. And ultimately sold 14.6 billion XRP without registering it as a security. And then we go on even further. Now they're going to Larsen, who did the same thing. He sold 1.7 billion without registration of it being a security. Garlinghouse violated sections 5A and 5C as well, because he went on to sell 321 million XRP without registration statement, in effect, as to XRP. And again, they're citing directly or indirectly making use of the means of instruments of transportation or communications in interstate commerce. That's between the states, right? And they directly, so they're saying they're enjoined to violate the Security Acts and they cite the specific code in the acts right here. There we go. And then they're also coming in here for the second claim of relief. This is aiding and abetting the violations of the Security Act, 5A and 5C. And it goes on to say that they went ahead and they sold. So the first two were personal. This is Larsen and Garlinghouse. Now they're citing the fact that Ripple, 2013 to present, went on to sell 14.6 billion XRP without registration, right? So they didn't register that as security. So they're just kind of laying out their complaint here. Larsen, and then what they get into this section is Larsen and Garlinghouse both knowingly or recklessly provided substantial assistance to Ripple to violate these sections 5A and 5C. So aiding and abetting means they assisted Ripple, the company, with going ahead and selling this, and they're citing Larsen and Garlinghouse specifically. And by foregoing, Larsen and Garlinghouse are liable pursuant to Section 15B of the Securities Act for aiding and abetting Ripple's violations of the 5A and the 5C. And then the personally enjoining defendants, so this is what they're saying. They're permanently enjoining defendants and each of the respective agents, servants, employees, attorneys, and other persons in active concert or participation with any of them from violating directly or indirectly, blah, blah, blah. It's a lot of the same type of stuff. Prohibiting defendants, one of the things they're looking for here, prohibiting defendants from participating in any digital asset securities pursuant to 21D and of the Exchange Act and 15 U.S. 78D and 5. They're ordering the defendants to pay civil money and penalties pursuant to Section 20D of the Securities Act, and granting any other further relief that the court may deem and proper benefit of investors. So this is one of the few sections where you actually see the investors being cited, but I'm not 100% sure what they're talking about. They go from talking about XRP up here and they say investors. Now I don't know which investors they're speaking to. Even though they're talking about XRP up here, I don't know if they're referring to the XRP investors. It may be more so the investors in the company Ripple itself, since this is against Garlinghouse and Ripple as the plaintiffs. And then of course we just got the signatures and blah blah blah. So I wanted to sort of point that out, just to kind of talk about what's happening here. And then so we got this pretrial hearing coming up. It's going to happen, and I would imagine that from Ripple's standpoint, Ripple's going to, yeah, sure, let's go. We'd love to have the magistrate judge. Ripple has no interest in drawing something long, painful, excruciating, a lot of legal bills. Problem with the district court is that by the time they get stuff added to the docket and stuff gets put up there, it's just a slow process. I know this. I do. There are some things that I know about the Southern District. It's not just the Southern District, it's any district, but on a federal level, having a magistrate involved, it's going to speed things up. Now, I don't think the SEC cares either way, and SEC probably be like, yeah, well, fair enough, whatever. They don't really care, but it's in everyone's best interest to put this latest to rest, right? There's a lot of stuff going on here. Shalaruja says, Europe, Asia, and Oceania holding many dollars, and many more of the Fed prints more worthless these dollars get. It's just an extension of U.S. empire attempting to govern the world. Yeah, in some respects, but the world doesn't need to worry about it. I mean, the world has already sailed beyond any of this, right? The world's like, see ya, don't let the door hit you in the rear end, right? They're like, don't let it hit you. And this is to some point a very valid point. It's reason also too that everybody's moving away from the dollar as a reserve currency. So we have GN McC here says, is there any federal legislation regarding crypto that determines XRP should be a security and not a currency? How does the SEC arrive to this conclusion? Why has the SEC gunned only at XRP? And I don't know what that second one is. You might have to clarify that. But the problem is legislation-wise, you can go to the courts and you can look at opinions, right? You can look at cases that have been won or lost. I don't think there's enough precedent there. I could be wrong. We're all highly aware of the kick, where the kin token and the violation of not registering that as a security, but that was an initial coin offering, right? They just and the ICOs were really cracked down as the SEC came after. But a lot of ICOs were able to go forth simply because they reached out to the SEC and they found out, what can I do? But an ICO is very different from this digital asset that is being utilized, the decentralized nature of XRP versus a centralized organization like Ripple. But I think this question is really good. Here is like, how does the SEC arrive at the conclusion? Well, they arrived at the conclusion by going back to the Securities Act of 1933 and 34, and then also looking as what they've deemed the Howey test, which is the orange grower up in Lake County, up here in Florida. It's right by Orlando. It was named Howey in the Hills is the actual name of the city where he renamed the city in his honor, which is cool. Good gig if you can get it. But essentially, they use the Howey test to deem whether something is a security or not. The problem is that, like the former FTC chair had said, Christian Carlo made really good points about it. Said even if XRP hit prong 1, 2. Prong one of the pieces, right? So a part of the Howey test, a second part, it doesn't hit all of the parts, right? So it's, in his opinion, it's not a security, not even. And it's also, he references Ethereum as well. How did they arrive at the conclusion? Using very old laws in the books that we've been tried. There's been an attempt to sort of update this through Congress. Initially we had the token taxonomy. There's been a lot of folks out there like Warren Davidson. You have Tom Emmer. You've got some people in Congress, Darren Soto, who's out of northern Florida here, who have made all kinds of attempts over the past couple of years to push legislation through to kind of update these old, tired laws. So and the reason they're gunning after XRP, that's a great question. Why XRP? Why Ripple specifically? Well, I guess I have my... I guess I have an idea. Ripple's a very prominent company. You're looking at what we look at, what JP Thero referred to as the SEC as the lion. Well, if you look who the lion and the big dog is, the $10 billion company in San Francisco is Ripple, right? And what's Ripple been doing all these years? Screaming for some guidelines and some regulation. Hey, where are the goalposts? So we don't know we're doing something wrong if there's no clear. I would say guidelines, but there's no legislation. There's no laws in the books that say, hey, do this, don't do that. And Ripple knows this firsthand because they overstepped. They made a mistake early days. FinCEN came after them. They corrected it. They got fined. And guess what? Game on. Now, what's happened to the SEC? The SEC's turned into litigators where they're going after everybody in the space. They're just going after the litigation part of it, right? They're going after people and hammering them. And, look, FinCEN, that's what they do. They root out the bad actors. The SEC's primary responsibility is supposed to be around consumers, which JP Thero makes that very evident and clear in his tweet. So that's a very good question. Very good questions you put forth there. Let's see. What do you think about Ripple dumping XRP on retail price manipulation? All right, so this is one of the other things that's being alleged, Mastiff Pitbull. One of the things that's being alleged in here, one of the allegations we looked at yesterday was the fact that sometimes they're alleging that Ripple would wait for maybe key announcements or partnerships or some type of news before they might execute a sale. But the way I look at that is that when you're looking at a company, and we found out too by deep dive in this, we also discovered that Ripple, they say, well, Ripple is releasing 1 billion from escrow, and then they're going ahead and selling it. And then you've had Garlinghouse and you've had Larsen selling as well, right? But one of the key things I think it's important to realize here is that there is a third party involved. They describe it as a New York-based that was registered with the SEC up in December of 2019, and this is really a lot of the communications that they talk about through this this exchange. We're doing a lot of the third-party work and actually executing that. Now, dumping on the retail, it's something that I wanted to get into today because there is an email that they call out between Garlinghouse and two other people inside the organization, and Garlinghouse brings up the fact that he's asking the question whether or not selling this XRP is affecting the marketplace. Does it have a negative effect on the price of XRP, right? But it's a question. So what? I mean, and the other thing that they've alleged is the compensation package, right? The fact that there were compensation packages that included a good amount of XRP as part of compensation, right? This is another thing that they're alleging. Now, the price manipulation, I'll be honest, you can have whales out there that can move and they can add and they can do all these kind of crazy things, right? They can actually do a lot with regard to price. The problem is, and there is a lot of manipulation. It's one of the reasons that I'm not into TA. I don't, the charts and everything. It's until we get more regulation, until we get a little more clarity. I do believe very, very much so when we're looking at charts and inside of stocks, because it's a little bit different. It's heavily regulated, and there are a lot of trend lines. I just don't see it happening for crypto. There's too much manipulation. We see this happen often with Bitcoin, right? The fact that there's no, with regard to investments and everything else, whales can affect the price. We've seen the thing where you can just you get a lot of people dumping, selling at one time and buying in. It doesn't affect us, but if you dump something at 50 cents and it drops to 44 cents, so you dump at 50 and back at 44. If you own millions, you got a nice price spread right there. I don't really believe so much in the fact that I do understand the concerns of Ripple with worried a little bit about if their actions as a company and a corporation are affecting the price of XRP, but I'm not so sure I believe so much in the manipulation. And when you say dumping on the retail, dumping on the retail, there's a lot of funding that happened with exchanges for the ODL product, I should say, as well, to create that liquidity. We've certainly seen infusion of XRP to MoneyGram, and then we've seen recently Ripple take the stance that they sold off a good portion of that. People question that, like why would you sell off something? But look, they're not in the business of running this thing. They're in the business of helping it to kind of grow. So I hope that answers your question. That's just where I'm at this. Okay, so Maxwell's equation says, how does double jeopardy not apply here given the post-FinCEN ruling? Double jeopardy happens in cases where you have like a murder case where you can't be tried for the same thing. This is a little bit different in the sense that there's nothing there that would entail having a regulation or something you could cite. What we're citing now is 1933 and 1934 Exchange Act and the Howey Test in 1946, and that came out of a ruling. It wasn't something where they set this up. It was because of how they ruled and how the court ended up, what the outcome of the court case was, that it became known as the Howey Test. It's not something that, and I'm not even sure that's the good terminology, the Howey Test. It's the Howey ruling. And that became the precedent that's set forth. This is a great way to figure out if it's so double jeopardy doesn't really apply here. There's no the jurisdiction that they're looking at, and also the regulation. But again, just my opinion. And also there are two different governmental agencies. So you're not being tried in the same court. So, but it's an interesting question though. Let me see what else we have here. There's another question I saw. Okay, so XRP Chance says, hey, do you think that the XRP being released from escrow on a gradual basis will actually go in Ripple's favor in court? I've kind of been on the fence about this one. The whole idea of the escrow, one of the things the SEC alleges and throughout this complaint, a pervasive theme that happens throughout this is the whole idea that when Ripple was going to either grant, let's say like someone like like Spring a certain amount of XRP, or they were going to go ahead and give it to, let's say, some sort of a startup. The SEC has the opinion that they didn't put any restrictions around it. But what I think they're really doing there is, they don't want to call it a currency, but what's happening there by them saying that they were upset that there was no restrictions around it, no lockup periods, and there have been lockup periods, there have been. But for the most part, what they're talking about is if this was given out and you had 100 million XRP, it was given to MoneyGram, so to speak, and this is just I don't know what the actual amount was. As soon as it hit their wall, they turned around and sold it. Well, what does that tell you? It tells you that it's a currency. It has a value, and it's working exactly like a digital asset or a digital currency would have, right? So you would take that, and then you can instantly change that to fiat. So what are they proving here? And what's their complaint there? It really is a currency. So releasing this from escrow on a gradual basis, I think their initial idea is a very strong one. You don't want to have that available, and the fact that they can't touch it, or the only ones that can decide on what happens with that escrow are the validators. So you have to put an amendment forth, and you have to have the validator nodes, which Ripple does not own. I think maybe it's 17%, but it's a very small majority. And recently there was an amendment that was passed that the Ripple validator voted no on. Everyone was overrode because they don't have 51% majority. So this also goes back to the idea that was expressed earlier by JP Thero, saying that in the early days, was it a security and could it have metamorphosized into something else? Well, it absolutely could have, and that's what I believe is probably going to be asserted here. He's very perceptive in that, because early days it was centralized, right? It became decentralized over time, and over time that certainly changed what XRP is, but it's a digital asset. And then you got to go back to other precedents that are set. But it potentially could go in their favor in court, because they do have some rules and regulations about it. Now, it's not going to affect the outcome of whether or not it's a security, but if the validators, and David Schwartz brought this up, if the validators wanted to vote on an amendment that said burn that supply, they could. And he brought it up saying it's a very real thing. Now, he would disagree vehemently with that, but he's saying that, the same way that Stellar Corporation burned 50 billion of their supply, they had 100 billion as well. They burned 50 billion. Now it's 50 billion. It's less, right? It's more scarce because now it's only 50 billion. Now, the way it works with Stellar Foundation is very different. The way it works with Ripple being centralized and the XRP digital asset being decentralized. So anything that has to go up for a vote to the validators certainly has to go to in a way that I believe would be put forth in some type of an amendment. But it certainly exists. And the fact that they have a lockup, you might see the attorney or counsel for Ripple say that you're alleging that we don't have any lockup periods when we have a lockup period designated by our own rule set that says we can only release X amount into, a supply, right? They do have something like that. So that'll be interesting to see how that goes forward. I did see another one in here. Let me look here. Okay, so let's see this. So Maxwell Equation says, hey, this is stupid. If Microstrategy, and this is Mr. Sally, he's the one who the CEO that bought in, I think he's now has 1.6 trillion or $6 billion worth of Bitcoin, because he bought in a couple hundred million when it was 10,000 per Bitcoin, and he bought it in again at 12,000 Bitcoin. So he's saying if MicroStrategy sold some of their Bitcoin funds, would they be sued by the SEC? I don't see why that would have any ruling with the SEC. The SEC has already deemed that the fact that Bitcoin is not a security. So they're not selling unregistered securities, they're selling a digital asset. Now, what I think your question more focuses around the fact that MicroStrategy is a company, and it's not an individual. So you have a company who is selling a digital asset, and I'm not sure if MicroStrategy is public or not, but I don't believe there's any conflict there. Yeah, Michael Saylor, that's his name, sorry. Michael Saylor hyping Bitcoin because he raises his company's stock value, deep rabbit hole. Yeah, but Michael Saylor, the fact is of his company, now he's not the only one. You had Square, you had a bunch of people put in for that. There's a really brilliant chart that, see if I can find it, I'll see if I can put it up on the screen, but I don't think there's any wrongdoing there, and I'm not really even sure that there would be that the SEC would have any issues with that. I don't know, you guys can tell me if his is a public company or not. I don't think it is. But I could be wrong. But I don't think there's any standing there. actually the chart that I'm looking for, I don't know if Jeff's watching, but if the chart I'm looking for was put out by Grayscale. Grayscale, who runs the XRP fund and also runs the Bitcoin trust fund too. Now they've also doubled down, right? So there's some articles put out there saying that, oh no, they're running from, the Grayscale is running, and that's Barry Silbert, is running away from XRP and XLM. It's contrary to what I've seen, which is they've increased their holdings. So. Maxwell equations. My biggest issue with the whole thing is how this went on for so long as it did, and the day before Jay and his cronies leave, this case suddenly appears. A bit disappointed how they handled that. Yeah, but like I've stated here, when you go back to what we looked at a little bit earlier, which is the tolling agreements, the fact that they had tolling agreements in place in April of 2019, that tells me that, now I don't know if discovery was happening. In other words, were they requesting documents? But the fact that they have all these emails, these were provided by Ripple. Okay, so there's some kind of discovery going on there. Now, if they're requesting documents and internal documents and email communication, and they had a tolling agreement in place in April of 2019, that sort of tells me that if they were communicating in the interest of potentially settling something, where Brad Garlinghouse mentions that in his memo to the employees, stating that both he and Chris Larsen could have settled this out of court. They chose not to, and there's a good reason. Well, we don't know what the settlement might have looked like, but when we look at what happened with the Kit case and with the Kin token, what did we learn? We learned that nothing happened. So they settled the case. We didn't get the Howey case. We didn't get the Howey test 2.0. We just got a settlement and a fine of $5 million. Settling wouldn't have changed. Would have had the same issue that would have been pervasive, which was there's still no clarity. There's no regulation, no clarity, and now they're asking for something. So that's a very interesting thing right there to kind of take a look at. Let's see, what do we have here? There was another thing I saw here. Okay, so here's one. So Texas Crypto says, hey, playing devil's advocate, if Ripple's $10 billion valuation was based on XRP, then XRP is a security. If not, then it's a currency. Well, I'm interested in why you put it that way, whether or not it's a currency or not currency. The valuation of a company is based on what they believe it's worth, and really where that comes into play when they're doing a fundraising round. Now, last December of 2019, Ripple went ahead and they did a fundraising round where they raised $200 million. Now, $200 million on a $10 billion valuation of a company determines what the actual percentage of holdings is, right? So you simply divide that 200 million into that 10, and you come up with the percentage, and that's where the valuation of a company is based on a lot of different factors. Now, it's not necessarily tied directly to XRP, and if you look in this court filing here, one of the things that we see is there's a direct correlation between the money that Ripple earned from their software. Now remember, they install software, and then it became something that they had to install. It took 2 weeks. Then they moved on to cloud software that could be executed in 2 to 3 days, and I'm sure the cost was less. Now they made millions of dollars with installing this, RippleNet, XVIA, all this kind of stuff that they installed, that they earned money from that. So the potential is on a lot of times the valuations has a lot more to do with what they believe the company. There's a lot of things that factor into that. What the company is worth based on their business, what they've done in the past and what they plan to do in the future. Now, I've seen companies and corporations have out of the gate a $2 billion market cap, the worth evaluation, I should say. They've done nothing. They have no track record. They only have the track record of the founders. But again, this is really comes in big when you're using the valuation of a company, and if there's agreement from the investors to move forward, because that determines how much they own. So now if you look at SBI, Katao, he owns, I think, 9-point-some%. So the valuation, the reason he owns 9% of the time had to do with the valuation at the inception, at the time that he went ahead and he invested. So I don't believe the 10 billion evaluation has really anything to do with XRP, whether or not it's a security, or it's really tied to it. Because remember, Ripple utilizes XRP, but it utilizes it inside its software, and it also has a very vested interest in other companies creating use cases for XRP. Notably, we have Flare with the Spark token and the fact that how it's going to be used in a smart contract. So that's something to take a look at there. So let's see. Is there anything else here? Let me look at some new comments here. Okay, so here we go. So João Arujo, I can't even say that. I know it's Portuguese, but anyway, dumping on you should sound your name out in there so I know how to pronounce your name. Dumping on retail looks bad short term, but in the long run, it's good for retail. More distribution will make the price harder to manipulate once XRP moons and gets adopted more and more. Yeah, I mean, I don't think I'm not even 100% convinced that really has anything to do with it. You know, Jed's been selling his. Here we go right here. So here's XRP Chance. You think Jed and Stellar made the decision to burn 50 billion XLM because they got wind of the lawsuit against Ripple? We're trying to get out of the line of fire. Yeah. So two steps to that question. So going back, the dumping on the retail. I mean, you know, when they would do a release, I'm not 100% sure. We've seen a lot of stability. I mean, how long were we oscillating between 19, 20, and 21? We saw some movement up to 25 cents. Then we oscillated, you know, around 29. I mean, for the most part, I mean, we joked here that XRP is our favorite stablecoin because it doesn't do a lot. There's not a lot of volatility in it. Yes, there's volatility. Yes, when this SEC case was filed, it had a huge impact and dropped and just crushed the, dropped the bottom out. But then there was a lot of people selling and certainly a lot of people buying. If you look at Fiat Leak, right now, Jed, I don't think that decision had anything to do with this case, but who knows? It might have. But even if he sells 75 billion and there's only 25 billion left, I don't think it changes anything whether or not it's about this what's alleged in this complaint. But he stopped selling it because he's a founder, and we just read why they want injunctive relief. They want relief in the fact that they want the founders to stop selling it, even though they don't specifically call out Jed. They do call him out as a partner, and they refer to him throughout that. But they're calling on the fact the SEC wants all trading halted. Not a good look if you're sitting if you're going to pull a kick and say, "Oh, we don't care. We're just going to start selling this stuff." You know, if Garlinghouse is like, "Yeah, I'll show you. I'll liquidate all mine." No, that's not what's going to happen. They're going to, of course, comply, and that's why Jed stopped his money train. But we know he's been dumping all along. Dump. It hasn't made much of a difference. The 1 billion that gets released out of escrow, some of it was purchased on the in the marketplace. Some of it was not. So some of it was returned. So I don't necessarily. This is the whole thing about the manipulation of price. Who really knows what manipulates price? Can it have effect? And this is what Garlinghouse is asking as a question. Could this potentially have an effect? And that's why you ask questions. It's not like there's you're going to get, oh yeah, it definitely affects the price. If that's true, where's the evidence? Show me the evidence every time you had an escrow release and the price of volatility just dropped. There's times where it's increased. So there's a lot more going on that has to do with the pricing and the manipulation of that. So Organic FUD says it's time to protect yourselves, not wait for someone else to do it. This is how the mafia, like letterboy agencies, like the SEC, get the power they have. Don't submit. Yeah, I agree with that. Yeah. So there's all kinds of ways, like I've asserted here that I've never sold any XRP. Only in the fact that I believe in it. I believe in the use case tremendously, but I also hold other assets as well. It's not the only one. It makes up the majority of my portfolio, but it's certainly not the end all be all. But I think there's, Stuart Aderati said it best. There's a lot of mistruths, a lot of cherry picking going on. So you have all this data and you can craft anything you want. Have you ever seen a full interview of somebody and they pick out the points? They pick out just a little snippet here and a little snippet there and put them together and you're like, whoa. But it turns out that if you hear it in full context of the full interview, this is what happens when you do cherry picking. You're only seeing part of the story. You're not getting the whole story here. You're only seeing that little snippet part of the story. So now what we were going to do today, a little bit off track, but we were going to go deep dive some other stuff here. I know that I think we're going to we're probably going to continue that on tomorrow. I think we probably will. And but I do want to answer a couple more questions here because I really like these questions are really good. They're really provocative questions in the sense you guys are really thinking about this. I like that. And again, I'm just giving my opinion. It doesn't take away from your question. You might disagree with me and saying, "Oh, I don't see that at all." Again, that's just my opinion, and I'm not I'm an advisor, a financial advisor. I am an advisor in other capacities of my professional world. A financial advisor. That's not me, right? I go to Channing Smithson for that. No, I'm just joking. I joke with Channing about that, but no, I just my opinion based on what I've seen in a lot of the cases that I've looked at. Lockdown level 10. So what is this about the lockdown here? Let me see. Okay, so what are you saying, Michael? I don't care how long it takes, and I'm on lockdown, can't spend the money. Oh, where are you based again, Michael? Are you in the UK? I think you're in the UK, right? That's very oppressive over there. In Florida here, you know, we've completely forgotten about any of this, and we just live our lives normally, you know. So, yeah, you know, it's good if you're on lockdown, you don't care, you can't spend it. Well, there's always, you know, my best way to spend stuff has been Amazon. So that's how I look at that. Which will be over the first court case or lockdowns? Place your bet. Which will be over first? My bet is on the potential the court case. I don't think these lockdowns ever end, and here's why. Is anybody, you know? And again, I don't want to get too deep down this rabbit hole, but here's what a question I'll pose to you: isn't it odd that the day, the week that the vaccine comes out, there's a new strain? Wow, that. And then you have some of the one of the pharmaceuticals saying, well, that's cool because ours works against the new strain. So I don't know. There's a lot of weirdness going on. I think this was a big test in a lot of other ways to see, you know, what can people get away with. At some point, people are fed up with this. You know, they are. They're fed up. I mean, they're walking around without, you know, these masks, and if the masks work, why the physical distancing? If that works, why the mask? If they both work, what are we worried about? If everyone's been wearing masks, why is it continuing to go? So it doesn't do anything, right? We're pretty, you know, it doesn't have an effect. Jungle Bear, you can build a wall around DLT. The U.S. can continue to use the typewriter whilst the rest of the world is using Word. Yeah, right on. That's exactly right. You know, that's well said. You know, go ahead, you know, have at it. We don't care. The world doesn't really care what happens here. And you really shouldn't be too worried about it because, hey, if it's deemed a security, you just crushed any innovation in every company in the U.S. and a lot of the alt market. But guess what? Only in the U.S. So have at it. If that's what your intention is, how did you protect the consumer? You didn't. And that's what I think could be asserted as well. And that's what I love about JP Thero's his tweet thread, because he says that. He calls them out. Hey, you're supposed to be looking after the consumer. You're not supposed to be out litigating everything, right? And here's the other thing. They lose 2 out of 3 cases that have been elevated to the U.S. Supreme Court. They don't have a good track record, right? You know, let FinCEN regulate that part of it, and you guys keep everything else to worried about protecting the consumer at whole. So Mohammed Kuba says, what will happen when Ripple wins the case? That's a very good question. That's a question that I really like because, look, let's just mini workshop this. Let's do a little bit of guesswork here, right? Let's start thinking about what might happen. Well, let's suppose you get clarity that's been much needed, right? It's been much needed in the U.S. The rest of the world's already been there, done that. But in the U.S. as a whole, this could be the moonshot, right? The shot heard around the world. Why? Because you got the Michael Sallies of the world who said, I could either buy another Bitcoin for anywhere from 25 to 30,000. I don't keep up on it daily. Let's suppose it's 40,000 by the time. I can buy one of those, or what XRP could I buy with 40K, right? You're going to have a flood into the market, and this is my interpretation, my opinion, that will be, you want to talk about the point of moonshot right there, because now it's up to 70 cents, then it's $1.50, and at $3 it's a steal, at $7, at 15, at 30, at 100, okay? Because and Rand Newer, who's saying, oh, thank you XRP community, we really appreciate the fact that everyone's selling it and putting it into Bitcoin and the altcoin marketplace, and he's missing a lot of the in-between stuff. But listen, Rand, you'll be selling some of those proceeds off, and you'll be getting in there. You'll be FOMOing in, because that's what's going to happen. And also, a win like this will put this on every major publication. Every television channel is going to be talking about it. Every financial broadcast is going to be talking about it. It's going to be biblical. That's just me thinking that this is going to just be phenomenal. GDLT says, should we care about what happens in the U.S. and liquidity depth of the U.S. is unmatched? Look, I mean, that's a biased question for myself to answer. I believe, heavily that, in the U.S. there is some kind of liquidity, but it was brought up too that, the U.S. has some other problems with being able to print money like it's water, and that's not helping out anything. So it's kind of a two-pronged sort of a question right there. Chan says, the XRP backer's latest video entitled, "I'm taking a break." I haven't watched it yet. That guy works really hard and deserves a break. Yeah. Blockchain backer does have a knack with those charts. Even though I said I don't believe in charts, there's something he's very, very good at with reading those charts, I have to say. I've been very impressed. Let's see. Ripple needs the liquidity depth of the US dollar. SEC won't push away the best of the best. Yeah, gee, I think you're right about that. There's so much at stake here. What is the price of being right? The price of being right for the SEC is destroying an entire market, right? A whole, you're crushing everything. So that's why it's easy to be, and you can get a win out of it by going after fines and saying, yeah, deeming it wasn't a security early on, it should have been registered, but now you're going to have to pay the price, and you're going to have to pay, and blah, 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 and we'll wash our hands, and no, it's not a security, and boom, now. And I think that's more it's in the best interest of everybody to settle this very fast and not get too heated about it. John Burns says, Burns says, hi Chip, missed all this. It was covered earlier. As the U.S. Exchanges suspend trading of XRP, what happens to the U.S. folks who wish to trade upon the court making a determination outside of what the U.S. can trade? Yeah, the trading part of it is going to become somewhat potentially difficult. Once the determination is made, even if it gets delisted, believe me, if this gets delisted and it's deemed not a security, you're going to have these exchanges falling over themselves to get this thing listed again, right? Because they get a fee every time you purchase. You purchase, they make a fee off it, and they'd be silly not to incorporate that. The whole idea of trading, like for example, what's been stated by Coinbase, a U.S. regulated exchange, saying that no more market orders. The limit orders are going to be available until, I think, don't quote me on this, January 20th or 21st, and then they're going to suspend all trading. Now, I don't know that would, if you wanted to then turn your XRP back into a fiat or turn it into something else or move it someplace else, or there's always a way that you probably could get it done. But under a regulated exchange, Uphold, we read JP Thero's tweet here earlier where he stated that until there is a ruling, they're not going to do anything different. So what I think that does, and again, you got to remember, this is a complaint. People are flipping out over this thing. Guess what? Complaints happen all the time. I've been a subject as a startup that I had in the early 2000s. I had somebody coming after a judge saying to my company they needed to shut me down. And they got a judge up at 2 a.m. to sign an emergency injunction against the company that I had at the time. And they wanted to shut me down and had to pull me into court, had to pull me and my attorneys in there and the rest of the team in there to go ahead and battle this thing. The judge, first thing the judge says is, what the hell was so damn important that you got me out of bed at 2 a.m.? Uh-oh. That's where I knew it was going to go well. And then, of course, my attorney, being the brilliant man that he was, cited an interesting code that the judge called him on and said, where is it? And he didn't have it with him, so there's a giant book sitting up there, and he had to go up there and look at it and actually flip through it. And the judge was getting a little bit disturbed by the time that it was taken in the courtroom, and everybody's sitting there. And a minute felt like a year, right? And he's like, I'm almost there, I'm almost there. I almost have it, I almost have it. He reads it. Judge says, dismissed, gone, whatever, bye. And so a complaint, an injunction, all of this stuff, until it's actually settled in a court of law, it's just that. They're allegations, right? Allegations that are made. You're innocent until proven guilty. There is no, even the pretrial hearing is just that. It's a hearing. There's no court date set on this yet as far as when this is going to be litigated in a court of law. And I stand on the side of Ripple thinking they've got an amazingly strong case here. They're going to come out the winners and be victorious. And because it's so thin that I don't think it can continue. There's so many cherry picking going on there and stuff. But you know what? Bring it on. This is the greatest thing that's ever going to happen. But let's not lose our minds over this. And Uphold is on the right side of history, in my opinion. Uphold is saying, right now, It is not. It's not been deemed. There's nothing that we can go back or any case law that we can cite, regulations that state that XRP is a security. So we are going to operate the same way we've always operated until there's a ruling that says XRP is a security, or until we deem it not to be a financial business model, meaning that if the trading value dropped to, like, people were buying 8 XRP a day and selling 10 XRP a day. I don't see that happening, but it's a real possibility that he's citing. Those are the only two conditions where Uphold stands, and I feel that Uphold is standing on the right side of history. Now, I totally understand why Coinbase is suspending. Coinbase is going through an IPO, right? They have initial public offering. They're going to go from a publicly held company to a publicly traded company on a stock that has stocks and everything else. The SEC is the governing body. Now, even the fact that they were able to still process limit orders and give enough time, I think that's very generous. But look, they're in no condition, and I knew that right off the bat. But the way they handle it is phenomenal, because they're still allowing the institutional custody. Remember that you have Coinbase, who also, one of their big businesses, they have $3 billion plus under custody. They do offer professional custodian services for institutional investors. So what they're saying is that the institutional investors will still be able to go forth and still custody the asset. And they're also saying you, as a casual investor, right, retail investor, can also, they're not going to change anything with the custody, right? So the custody is going to remain. They're not saying you have until January 20th to move your digital asset off. No, that's not happening at all. And again, the reason they've got to come down on a strong side is because they don't need any trouble, right? They're not looking for any trouble here, man. They're like, hey, we want to be clean. They're doing the right thing. I think for a company that's going public, they're approaching this and handling it the right way. But man, Uphold, I was already a big fan of Uphold. I just became a massive fan of Uphold. That tweet right there, somebody standing up. There's this groupthink that happens in the world where so many people have an opinion, but you're sitting there going, that doesn't make any sense to me, man. I just, but it's a lot more difficult to be the one that speaks up and says, I don't get this. I don't believe in this. And you got someone like JP Thero, who is the co-founder of Uphold, saying, hey, man, I'm making a stand. Flagging, we're not going anywhere. Only two conditions. If it's deemed a security, okay, fair enough. If there's no trading volume, fair enough. But other than that, game on. So what do you think is going to happen? Trading is going to continue. Uphold is going to see a surge on their platform. And until we get a ruling, and even if it is deemed a security, I believe it will be deemed. I believe these words of JP Thero will be looked upon when they come back and say, hey, what if it did metamorphosize? What if it was a security, but then it metamorphosized into something else? And what if Hester Pierce floated an idea about safe harbor, that you could create something as long as you then were able to release a digital asset that was decentralized? Interesting, right? You think the counsel for Ripple will cite any of that or bring that in? That's a good possibility. It's a possibility that certainly exists. What is Paul saying here? Paul Trainer says, hey, Chip, really interested to know if Ripple is buying XRP on the secondary market while the price crashed and have lots, they're sold, or are they making money off XRP, off our backs and losses? I highly doubt it. Now, look, anything is possible, but I severely doubt that that's happening. But and I don't ever believe there's any ill will put forth by Ripple. Even some of the allegations where they say Ripple timed things. Well, guess what? As a company, you have to time things. And everybody took a lot of offense at the fact that Chris Larsen and Brad Garlinghouse were selling. Game on, the IT company called Snowflake, that CEO makes $100 million a month. He makes $1.2 billion in compensation. They're talking about small things here. $450 billion. You're already talking about, he's already a multimillionaire several times over, Chris Larsen. They didn't cite anything in that allegation about all the money that Chris Larsen has donated to charity. That was weird. That wasn't in there. So yeah, there was good things are being done, and Chris Larsen, has done a lot of good too. So I do believe that certainly certainly bodes really well. So I think there's a lot going on here that we'll continue to break down over the next couple of days. I like this Q&A session. I've really been happy with you guys are really asking great questions. And again, I'm just giving my opinion. You may disagree with it, and that's fine. And you can even come back in a comment on why you disagree. We can actually debate it as well. But I'm not, I'm just giving a standpoint from using my professional business background and coming at it with those eyes. The same way you may be leveraging it from your background. Maybe you're an attorney, or maybe you have a way of looking at this that I don't. Bottom line is, when we come in and workshop this together, we learn a lot about. We start looking at some other things. And it's a lot of fun to do. So, and that's one of the things that I've enjoyed about putting this together and doing it. So it's been a lot of fun. And if it's your first time here, like, subscribe, click that notification bell. And Jeff dropped a really cool video today on the other channel. If you go down below, if you're not subscribed to our other channel, we call that the standard channel because we just do uploads there. Short little pieces of uploads where Jeff will put up the how to review. I'll put up some XRP minutes. This is our live channel. This is the channel we only do live streams on. So we've sort of designated the two. And you go like, well, maybe you should have one. There's a reason we do that. A lot of it has to do with, and I'm not going to get into it here, but there's a reason we separated those out. But certainly, go watch that video. He dropped a really good one today. I dropped one. If you want to look at one that I had dropped earlier, I think it was yesterday or the day before. I think it was Monday. I take a look at the CFTC commissioner, who's Chris Giancarlo, makes the #1 best statement about why XRP is not a security, and I would go back and check that out. That's really great. Also, I get into the Department of Justice as well, looking at it and saying it's not a security. So anyway, that's me. That's my take. I enjoyed this time we've had together. Let's do it again tonight. Jeff and I will be on at 8 o'clock tonight. In just a few hours, we're going to be going through some of this stuff and some other news that's happening. So why don't you come back and join us? Jeff and I always love hanging out and being together with you guys. So come by. That's all I got. Chip out. Have a great one, guys. See you on the next one.
Are you down with OTC? Please like, subscribe, and click the bell to be notified when the next video drops.